On Friday, U.S. Marshals seized Ivanka Trump's passport. Based on legal documents submitted on Friday, February 6th, federal officers arrived at Ivanka Trump's residence in Miami at 6:47 in the morning. Upon their departure, they took her travel documents with them. The situation revolves around $127 million, 23 shell corporations, a probe lasting 2 years, and a deposition lasting 2 hours that caught everyone off guard. The host mentions he examined all 187 pages of the court filings, and that the information contained within those pages extends much further than what the news summaries reported. He states the authentic narrative shifts everything. A major revelation is that Melania Trump, in private and while under oath, discussed her stepdaughter Ivanka. The official documentation indicates she responded to 147 inquiries, paused once, and decided against invoking her Fifth Amendment right to remain silent. The host claims this is the instant that transformed the entire case, and he intends to guide viewers through the actual events. For context, Ivanka Trump previously served as a senior advisor at the White House and is the offspring of Donald Trump. She manages multiple commercial enterprises incorporated in 6 different states. The issue, based on the host, is that recently uncovered financial documentation shows a sequence of monetary movements that federal investigators allege amount to laundering money through a collection of limited liability companies, also referred to as LLCs. He emphasizes these are not his personal assertions, but originate from the legal documents. Here is a brief sequence of the case's events. Months prior, a grand jury was assembled in Manhattan and subpoenas, which are official commands to provide documents or testify, were dispatched. Ivanka's attorneys began contesting those demands for documentation. A few weeks ago, a federal judge rejected her effort to block those demands and mandated her complete cooperation. Then, just recently, everything shifted. Melania entered a federal building in Washington, D.C. 2 hours later, she emerged. The very next morning, U.S. Marshals arrived at Ivanka's residence. The host stresses the sequence of these occurrences is highly significant. Based on publicly released information, this probe commenced with the Trump Organization and subsequently expanded. Investigators discovered something inside the family's corporate framework that prosecutors deemed worth chasing, and Melania, for her own motivations, chose to collaborate with them. The host states this is the fundamental situation and that the documents clarify the reasons underlying it. He reviewed them 3 times over the weekend and extracted the most critical sections. The initial key document was submitted on Friday. On page 43, it states, using a direct quote, that the defendant facilitated moving money from Trump Organization subsidiary accounts to a company incorporated in Delaware that had no obvious valid commercial justification to exist. The host clarifies that is not his personal view, but rather what the court filing actually asserts. It indicates funds were relocated, and the final destination doesn't logically follow from the documentation. However, the portion that truly seized his focus is on page 89 in a separate segment. According to the court documents, between March 2023 and November 2024, Ivanka Trump's signature appeared on 31 distinct approvals for wire transfers that totaled $84.7 million. The funds went to a holding entity in Cyprus, a subsidiary firm in the Cayman Islands, and a business registered in Nevada that possesses no workers, no revenue, and no physical location. When you combine all of this, a distinct sequence emerges. Funds departed Trump Organization accounts were routed through Ivanka's personal commercial network and ended up in companies that exist solely on paper. All of this is recorded on pages 91 through 103 of the submissions. Now, here's a detail almost no one is covering. There is an exhibit designated as Exhibit F that is hidden on page 147. It demonstrates that verified financial records indicate Ivanka personally obtained $3.2 million in cash equivalents over a span of 14 months. The pattern of those withdrawals is remarkably precise. She never withdrew more than $9,500 at any one time. The host urges people to read that again. The amount was consistently $9,500. The significance of this is that federal regulations mandate banks to automatically flag any transaction of $10,000 or more. If you remain below that threshold, no automatic report is generated. The legal filing terms this structuring, which means intentionally dividing transactions to evade triggering those reports. Prosecutors contend this demonstrates she acted deliberately. As a consequence of all this, Ivanka's passport was confiscated while she awaits trial. Her bail was established at $15 million. Her movement has been confined to the Southern District of New York. All of this transpired within 72 hours of Melania's testimony. Here is the connection. The official transcript states Melania informed investigators that she was present for multiple discussions where Ivanka talked about maintaining transactions beneath the reporting limit. There is a direct quote from the filing where the witness identified as MT, which stands for Melania Trump, said that the defendant instructed people to keep it under 10, always under 10. That is located on page 156, paragraph 14. There is one additional crucial point. On page 162, prosecutors argued that Ivanka possessed specialized understanding of federal reporting regulations because of the position she held in the White House. They are not merely alleging she did it. They are alleging she understood precisely what she was doing and the reason behind it. To summarize the proof, there are 31 wire transfers totaling $84.7 million. 3 international companies that conduct no actual business. 89 cash withdrawals, all kept beneath $10,000, testimony from an eyewitness, and a pattern stretching over 20 months. Legal analysts are stating this represents one of the most thoroughly documented money laundering instances involving a former White House official in recent memory. It isn't just a single piece of damaging proof. It is an entire compilation of proof, and it is all accessible in public filings now, and that is merely the financial proof. Melania's testimony constitutes a separate and substantial element of the narrative. However, the host mentions he aims to be equitable and present the opposing perspective because the defense does raise some valid points. Conservative detractors claim this is selective prosecution, essentially a political assault employing the judicial system. And some of their points have merit. First, the timing is questionable. The probe intensified right before election season. That could be accidental or it might not be. Second, there is the matter of familial dynamics. Using Melania's testimony against Ivanka is something the defense labels manipulative, asserting that prosecutors pressured one family member to turn against another. Third, the structuring charge itself is not as simple as it appears. Defense attorneys highlight that withdrawing cash in sums below $10,000 is not automatically illegal. Prosecutors must demonstrate that the individual intentionally did so to circumvent the reporting rules. Alan Dershowitz, a prominent law professor from Harvard, stated that structuring charges necessitate proof of intent to avoid the reporting requirements, and that patterns alone do not establish a crime. The host says he doesn't concur with everything the defense asserts, but their points aren't insignificant either. They note there is no direct proof from the transactions alone demonstrating Ivanka understood the reporting laws. They question Melania's trustworthiness as a witness given the family conflicts. And they raised concerns about prosecutors overstepping. Even Jonathan Turley, a constitutional law professor at George Washington University, commented that this case prompts serious questions about utilizing family testimony and the timing of the accusations. The host says he isn't attempting to dictate who is correct. Here is the perspective of both sides. The prosecution's narrative is that the proof supports money laundering involving wire transfers, shell companies, and structured withdrawals, and that it constitutes a textbook example. The defense's narrative is that the proof reveals careless record-keeping, the typical disorder of a family enterprise, and political targeting, not genuine crime. Both interpretations are plausible, and that is what renders this case complex. Here's what the defense team submitted on Thursday. Their official documents state that Ivanka's attorneys contend the international companies had legitimate commercial purposes, including international licensing agreements and contracts for managing her brand. They provided 47 pages of business records, contracts with foreign firms, and revenue statements. Their stance is that the money moved because the business operations shifted, and there is nothing suspicious about it. They also directly challenged Melania's testimony. In their legal motion on page 23, they asserted that the witness identified as MT has substantial personal and financial motivations to offer testimony beneficial to the prosecution. In straightforward terms, they are suggesting Melania might have her own reasons for cooperating unrelated to telling the truth. Family dynamics are intricate, and everyone following this story understands that. There is also an awkward reality for the prosecution. Prosecutors have previously brought weak structuring cases and lost. The law necessitates proving that someone knew about the $10,000 reporting threshold and intentionally kept their transactions below it deliberately. Merely demonstrating it occurred is insufficient. That represents a genuine hurdle for the prosecution. A defense attorney named William Brennan, possessing 37 years of experience in federal criminal defense, stated the government requires more than just a pattern. They need proof that she specifically did this to evade the reporting requirements. That will be the focus of the legal dispute. The host mentions he can only relay what the documents reveal, and they show both sides possess strong arguments. The trial will be challenging for either party. But there is a justification for the judge permitting the passport confiscation. There is a justification for the bail being fixed at $15 million. There is a justification for Melania's testimony being delivered privately rather than in open court. The prosecution believes they have a robust case. This didn't emerge from nowhere. For additional context, over a year ago, the Manhattan District Attorney's Office broadened its investigation from the Trump Organization to individual family members. Subpoenas were issued. In the subsequent months, Ivanka's team contested every request for documents. They asserted legal privilege and executive immunity, but all those arguments were dismissed by the court. A few weeks ago, the grand jury prolonged its session, indicating they were not finished. A source acquainted with the investigation informed reporters on the record that they understood the probe had shifted specifically to Ivanka because the document demands became highly focused and targeted. What occurred next is typical when someone resists subpoenas. Investigators grew more inquisitive and began investigating leads. The pattern they observed was delayed compliance with court orders, incomplete document submissions, and inconsistent statements from Ivanka's legal representatives. Each time that happened, the investigators scrutinized even more intensely. The sealed indictment, which refers to formal criminal charges kept confidential, was filed weeks before Friday's arrest. Prosecutors maintained secrecy and bided their time. Regarding Melania's involvement, according to court documents, prosecutors contacted Melania in late January and extended an invitation for a proffer session, which is essentially a meeting where someone can disclose what they know. She consented, and that marked the turning point in the case. Before her testimony, prosecutors possessed documents and bank records. After her testimony, they gained context. They comprehended the motivation underlying the transactions, and they obtained direct witness statements about private conversations. Until Thursday, this was a case built entirely on paperwork. Thursday rendered it personal and human. One family member sat under oath for 2 hours and discussed another family member. That is the backdrop explaining why Friday unfolded as it did. Now for the specifics of what happened on Friday morning. According to court documents, U.S. Marshals arrived at Ivanka Trump's residence on Star Island in Miami at 6:47 a.m. Eastern Time on Friday, February 6th. They presented a court order and demanded her passport. Her attorney was on the phone within minutes, contacting the duty judge to request an emergency order halting the seizure. That request was rejected. The court determined there was sufficient evidence indicating she posed a flight risk due to her international business ties and access to private aircraft. That denial order was filed at 8:12 a.m. There was no room for negotiation. What transpired afterward progressed swiftly. The passport was surrendered at 7:23 a.m. A bail hearing was arranged for that afternoon. By Friday evening, $15 million in bail had been arranged. GPS monitoring was implemented before she departed the courthouse. All of that occurred in roughly 4 hours. While the media concentrated on the passport story, another development occurred that most overlooked. The court released a document called Exhibit G to the public. That exhibit comprises 67 pages of communications, including emails, text messages, and transcripts of voice messages. Then the judge took an unusual step. She mandated Ivanka's legal team to surrender all electronic devices utilized for business communications since 2021. This encompasses laptops, phones, and access to cloud storage. The deadline for surrendering everything is Wednesday, February 11th. Former U.S. Attorney Barbara McQuade characterized this action as extraordinary. She stated it wasn't a response to events, but a meticulously orchestrated strategy. You can observe it in the sequence of events. On Thursday, Melania testifies. Friday morning, marshals arrive. Friday afternoon, sealed exhibits are made public. Friday evening, the device surrender is mandated. Prosecutors were not improvising or reacting. They had a strategy, and they executed it systematically. One noteworthy detail is that the order to surrender devices came after the passport was seized, not before. This indicates prosecutors believe there is additional evidence to uncover. They already possess what Melania disclosed. Now they aim to verify it against Ivanka's own communications. They are searching for deleted messages, conversations on encrypted applications, and anything that either corroborates or contradicts what Melania stated under oath. This is the juncture that will determine whether the case strengthens or disintegrates. The devices will reveal the authentic story. Now for the perspectives of legal analysts. Rinaldo Mariotti, a former federal prosecutor with 15 years at the Department of Justice, stated that seizing a passport at this phase indicates prosecutors possess strong evidence and a genuine worry that the individual might attempt to depart the country. In simple terms, they don't take that step unless they are assured. Daniel Goldman, a former assistant U.S. attorney, stated Melania's testimony is the linchpin of the entire case. He observed that family witnesses are exceptionally powerful and exceptionally uncommon. The crucial point to grasp is that family members almost never agree to cooperate with prosecutors. When they do, juries regard it very seriously. Even Tim Parlator, who previously served as an attorney for Donald Trump, conceded that the structuring charges are grave. He stated that if the pattern is as thoroughly documented as the filing suggests, the defense faces a significant challenge. When individuals on both sides concur that the situation is grave, that ought to indicate something. The general consensus among legal analysts is that the volume of evidence is unusual for this preliminary stage of a case, that Melania's cooperation fundamentally alters the situation, that the device surrender order suggests prosecutors anticipate finding more, and that the passport seizure demonstrates they possess high confidence. However, there is disagreement as well. Criminal defense attorney Carolyn Pisani, a former federal law clerk, stated that structuring cases are extremely difficult to prove and that the question of intent is where prosecutors frequently falter. Constitutional law professor Ilya Shapiro added that people should exercise caution about celebrating when political figures are prosecuted because the precedent it establishes is significant. The host offers his own evaluation after examining everything. The prosecution possesses substantial material, including documents, witnesses, and patterns. The defense has complexity on its side, with legitimate business arguments, claims of family bias, and questions about intent. Neither side has a guaranteed victory. Despite what the headlines indicate, this is not a straightforward case. However, the passport seizure is a significant signal. Judges do not order that lightly. They examined the evidence and determined that Ivanka Trump might attempt to escape the country. That is not a neutral indicator. Former Department of Justice official Harry Litman stated simply that deeming someone a flight risk necessitates probable cause, and the judge observed enough to believe she might depart. Courts do not speculate. They make determinations based on evidence. The host then explains why this case matters to everyday individuals. If you hold stock in any enterprise connected to the Trump name, you should pay attention. Trump media stock declined 12% on Friday, and Trump Organization bond prices fell 8% by market close. Legal uncertainty causes that kind of financial harm. Your investment portfolio might be impacted without you realizing it through index funds, real estate investment trusts, or banking sector investments. Some investors are reportedly reviewing their exposure to politically sensitive assets and consulting financial advisors about adjusting their investments. This case also establishes a legal precedent. In the future, if you are ever involved in a business dispute or a legal matter, the rules regarding family members testifying could apply to you. For example, imagine your spouse possesses knowledge about your finances, or your adult children were present during a conversation. Under current law, prosecutors can approach those individuals, offer them immunity from prosecution, and ask them to testify. This case demonstrates they are willing to do precisely that. The protection known as spousal privilege generally prevents married couples from being compelled to testify against each other. But Melania was not compelled. She agreed to testify voluntarily. And when it comes to stepchildren, there is no privilege protection whatsoever. According to the court documents, the investigation has identified 23 individuals who received money from the network of shell companies. These include business associates, contractors, and consultants. Some of them have already retained lawyers, and others are reportedly cooperating with investigators. It affects everyone in that circle. There is also an uncomfortable truth that no one wants to articulate openly. If you have ever divided financial transactions to avoid reporting requirements, you are observing your own methods being prosecuted. This applies to small business owners, real estate investors, and anyone who manages a business that handles significant cash. The government is using this case to convey a message, not just about the Trump family, but about anyone who treats those transaction reporting limits as optional. If you have ever intentionally kept your cash withdrawals under $10,000, you are part of this conversation whether you prefer it or not. The host says he isn't attempting to alarm anyone, but that is what the legal situation implies. In terms of practical measures, informed individuals are reviewing their transaction records with accountants, ensuring they have documentation demonstrating legitimate business reasons for any cash movements, and asking their financial advisors whether they might be at risk. The IRS has increased its enforcement of structuring violations by 340% since 2020. This case is the most prominent example, but it is far from the only one. If you operate a business that deals with cash, or if you have ever divided a large purchase into smaller transactions, this is relevant to you. The host recommends consulting a professional and understanding the rules. On a broader level, whatever happens to Ivanka Trump will influence how prosecutors across the country handle high-profile financial cases. If they prevail here, they will become more aggressive everywhere. If they lose, defense lawyers will have a blueprint to follow. Either way, the rules for these kinds of cases are being shaped right now. Ivanka's response exacerbated the situation. Within hours of her passport being seized, her team issued a statement labeling the prosecution politically motivated persecution. The statement read, "This is a weaponization of justice against the Trump family that every American should fear." That statement was shared 2.4 million times on social media. The hashtag about freeing Ivanka trended for 11 hours on Friday, and fundraising emails were dispatched within 30 minutes. Prosecutors responded through a spokesperson by stating the evidence speaks for itself and that their office does not comment on political rhetoric. Then the judge did something unusual. She issued an order preventing both sides from making public statements that could influence the jury pool. This is termed a partial gag order, and it took effect immediately. That means Ivanka cannot continue appearing on television and in the media. She cannot keep labeling the case political. She cannot raise money directly stemming from the case. Her legal team objected and filed an emergency appeal on Sunday night. That appeal was rejected this morning. The order remains in effect. So now Ivanka's situation is highly constrained. She cannot travel internationally. She cannot speak publicly about the case. She cannot leave the Southern District of New York without obtaining permission from the court. She went from running international businesses last month to having her movements tracked by GPS this week. The situation is not de-escalating. It is becoming more severe. The defense filed 3 separate legal motions on Saturday. One challenges the passport seizure. Another challenges the gag order. The third challenges the timeline for surrendering electronic devices. All 3 are still pending, and the judge's response is anticipated by Wednesday. Several things remain unclear. First, what exactly did Melania say? The transcript of her testimony is only partially accessible to the public. What we have are excerpts that prosecutors included in their filings, not the full 2 hours. Second, why did Melania cooperate? No deal granting her immunity has been publicly revealed. No charges against her have been mentioned. She walked in voluntarily, and that does not occur without a reason. Here is what is approaching. The federal court has a status conference scheduled for Wednesday, February 11th. Ivanka's team is expected to argue for modifications to her travel restrictions. Prosecutors are reportedly preparing additional exhibits to present to the court. The date to truly monitor is Friday, February 13th. That is the deadline for surrendering the electronic devices. Whatever is on those laptops and phones will become part of the evidence. If messages were deleted, forensic experts will recover them. If encrypted messaging applications were used, prosecutors will know. If the communications align with what Melania testified to, the case strengthens. If they do not align, the defense gains leverage. Friday is the pivotal point. Also approaching, the grand jury convenes again on Thursday, February 12th. Additional charges are still feasible. The indictment that has been made public might not be the final version. Here is where everything stands at this moment. Ivanka Trump has had her passport seized, is out on $15 million bail, and is being monitored by GPS. Melania Trump's testimony is complete, and no charges have been filed against her. The order to surrender electronic devices has a deadline of Wednesday, February 11th. No trial date has been established yet. Additional charges are possible, and the grand jury is convening again on Thursday. The key dates to monitor are Wednesday, February 11th for the status conference and hearing on the defense motions, Thursday, February 12th for the grand jury session, Friday, February 13th for the device compliance deadline, and Monday, February 16th for the anticipated prosecution response to the defense motions. Several things have not been made public yet, including the full transcript of Melania's testimony, the defense witness list, and any potential cooperation agreements with other individuals involved in the investigation. The clock is ticking. The defense has 4 days to surrender the devices, 4 days to attempt to secure changes to the gag order, 4 days before the grand jury might add more charges. Meanwhile, prosecutors already possess what they need to advance, and they are not delaying. This case has progressed faster in 5 days than some cases progress in 5 months. And the host states that is clearly deliberate. When you see someone's passport, you are conveying a message to everyone, including the person charged, that you are serious. And prosecutors are serious. That is where matters stand. Ivanka Trump is restricted, monitored, and battling on multiple legal fronts. On the surface, this concerns a former White House advisor confronting serious federal charges. But Melania's role is the genuine story. Why she cooperated, what she actually said, and whether her testimony withstands scrutiny are the essential questions. The device surrender will disclose whether prosecutors can substantiate her testimony with concrete evidence or whether they are relying solely on her words. The judge's demeanor at Wednesday's hearing will be significant. How she handles the defense motions will indicate where this case is heading. The story is not finished. It is still evolving. What we know is that the evidence is considerable. The family situation is unlike anything witnessed before, and both sides are being aggressive in their legal approaches. What we do not know is whether any of this will conclude in a conviction. Cases like this have disintegrated before. High-profile targets, political pressure, and aggressive prosecution that could not complete the task. This case might be different because the documentation is unusual and the witness is unprecedented. But we are still in the early chapters of a long narrative.